So I think with the judge, I will. I'm gonna write to her today and tell her about the unavailability thing, just so we're not holding up that. But about the other thing, I'm going to um, probably do it overnight because there's quite a lot of material and I'm doing it in the form of an affidavit. Um, Now, I think I mean, this is clearly something that she has initiated. Um, and then, the registry there has basically followed her thing, just like what happened with Gorton. Um, so, what she's trying to do is, because she can't properly reject the documents because of the relevance thing, and like she understands from all the previous arguments with Gorton and everything which are before her that how I'm going to argue this. So she's basically getting the registry to do her dirty work. Um, that part, I mean, that's a clear inference that arises from it because
Someone's got to have prompted the registrar to put himself out like that, I would have thought.
not just that, but I mean, they don't actually check affidavits. They don't check affidavits, really.
Yeah, no, I understand. Yeah, that's true. I mean, that's right. What's in an affidavit? They can't. They can't because they don't have the purview to do so.
Absolutely, and also it's not something that they would usually inspect. And
No. They've got no right really of looking at an affidavit what it contains.
yeah, and the other, and it's especially relevant because the issues have not been argued. I mean, they don't even know how we're arguing the recusal application. Like there's no grounds that have been identified except for the material, and those grounds have not been substantiated through formal submissions yet. So it's just very haphazard. They couldn't have seen everything, and I think they're just reacting to the little stuff. That's the first thing. The second thing is I think we should also, um, I mean, we should raise this with everybody as well, like with the people that we're writing to, and we should talk about this and start the podcast now with the updates, continuous ones, because this is clearly her trying to um, interfere, and I think this is a significant thing for her to basically um, realize that she's done the wrong thing, then be faced with the criticism that she's faced with, see what happened to Gorton, and then preemptively get the registry to do her dirty work. And it's the Queensland registry that has done it as well. So I think it's clear. And I mean, the most scandalous thing is that there's no reason given there. He says I can do it because if it's vexatious or frivolous, and I think it's vexatious or frivolous, without even specifying which it is. I mean, he threw the word abuse of process. It's just ridiculous to say that. And I mean, even the Victorian registry didn't take that tact. Like the evidence is not something that you can examine, and the Victorian registry, in fact, has a clear policy about not reviewing affidavits. So this is I'm going to put that to her, and then I think we put to her that we are going to raise this matter in the new series that we've started with the Rule of Law brand, and then we do it because I mean, I have no idea what she thinks she's doing here with the manner in which this is being argued. The other curious thing is that the letter is dated 23rd June. It was sent to me after midday or thereabouts today. So it's dated yesterday. It was sent to me not even like the first thing. And it was only sent to me after, it was sent to me at 11:52. So 8 minutes before midday. And after I wrote to them and said that, I wrote to them at 10 o'clock and I said that, why haven't you sealed the documents yet?
Yes.
And even then they didn't send it to me. And it's the same guy who forwarded it to me. And apparently the letter was done yesterday. So, I mean, presumably he got it yesterday. Because if the sender was sending it, original sender was sending it to him today, then he should have changed the date to today. So I don't see why he would have held the letter out for so long, and even almost 2 hours longer than 2 hours after I had written to him. So it's just, I think what has happened is that after I raised complaint and pointed out that she has accepted it, the listing of it, without it being accepted by the registry, then they have tried to pretend like it was accepted yesterday, and that's why she agreed to list it. Because they didn't notify us yesterday at all. And
no, but I saw the timeline of when it came in. I thought it was. But
yeah.
I saw that we at 10:45.
Yeah. So I'm gonna do that, and then
I mean, this should embarrass them, really, should it? But we've got to find the person who's going to stand up for us.
this is them trying to, you know, find some. I always say that the best situation, the best demonstration of your skill is to, you know, frighten the other party so much that they start cheating preemptively, in a way that they know they would all, or if they thought about it, they would realize that they would obviously get caught, because it just means that they know they have no basis to legitimately. It means, one, they know what they want. Two, they know what they want is unlawful. So they're trying to, you know, break the law. And I mean, with her, she first did it covertly, like under the wraps, so no one would know. And now she can't do it that way, so she's doing it, you know, through other underhanded means. But anyway, I just don't think that they can legitimately prevent any of that from being adduced. And there are mechanisms built into the law for things of this sort to be checked. I mean, a lot of people have to do the wrong thing at the same time for it to continue this way. So anyway, I will. I think we may just need to raise the constitutional issue if if they don't accept our filing. And the other thing is that, so we'll have to ask her to refer the matter to a different judge, basically, because she can't decide on the admissibility of evidence against her, or she can't review the decision of the registrar, especially before her recusal application, and in circumstances where the evidence will go against her. And she's not going to be an objective assessor. Plus, the jurisdictional issue is a problem. So, she should refer the matter to a different person. And by the way, there's no basis upon which it can be said that a recusal application cannot be heard by a different judge. It's just normally heard by the same judge. That's the law, but there's no basis to say that it cannot be heard by a different judge. So, at the very least, the admissibility issue should be decided by someone else, or
Yes, I would agree with that.
or the registrar should back off. Is one of the two things that can be done. So I'm going to do another affidavit, and then I will put in there what happened, and that we put the first affidavit, and I'll exhibit the first affidavit and the documents exhibited to it. And by the way, all of this happened because she wouldn't give us the 3 days that we needed to make the application. You know? Like, she made a very, very unnecessarily tight order that within 24 hours, business hours, we file the application or we get summary dismissal. And I mean, there was no way we could argue everything we wanted to argue properly and, you know, refer to the thing the way we would have liked to. So we tried to retain all the relevant information in the through the document. So it's what they really want is for you know, matters to be decided other than on the basis of objectively determined facts.
Sure.
Because it's not convenient, and then they use the excuse of this will be quicker this way, and that's what we're supposed to do. I mean, you're never supposed. Sorry?
I was just going to say that normally, as you know, I think on the conservative side, but in this particular matter, I really think something stinks.
I mean, it's not something I've identified what stinks.
Oh yeah, no, I'm talking it's a generic term for everything that we've raised.
Yeah.
I go take the word and say, in this matter, it stinks. There you go.
Yeah. And also, by the way, I found an authority. This is absolutely critical. It's an authority, High Court authority, Director of Public Prosecutions versus Smith. Actually, it's from last year, yeah. So, basically, this referred to another authority where that had happened. So, in this authority, what happened is the judge, the prosecutor, and the accused's lawyer, they all had a private meeting with a underage complainant. So basically, I think it was a sexual assault case where the victim, or the person presumed to be the victim was, or alleged to be the victim was underage, and they had a meeting to see whether, you know, they should be giving evidence in open court or whatever. And then the accused challenged the decision that was made against him on the basis that he was not present during the meeting, and he has a right to be present throughout the process. So his lawyer was present relevantly, so it wasn't without his lawyer, but because he was not present, he raised the thing, and the High Court found that that was not violation of the thing, but they set out the important principles, and also they refer to an important authority where basically the effectively what happened was similar to what happened with Gorton, in that the prosecuting agency spoke with the judge privately before the case had commenced to get some directions or agree on a process in terms of how the administrative aspects of what they were trying to do would be achieved. And it was found that the case was, yeah, this is the one. This is also so the court found that the right to a public and fair trial was denied because the private meetings before the trial were part of the context of the trial, so it wasn't an open trial anymore. It's exactly what we've been saying. So whatever happened in private, that basically, I mean, the point is that the person will never know the extent to which that has affected things, but it can never be said that it didn't affect things. That's the crux of it. So it was found that the right to a fair trial had been, or public trial had been denied, and this is, so it was on the basis of the open courts principle, basically. And they lay out some very important rules which are relevant to the authority anyway. So our point is that I was thinking about this, like even for the recusal application, she would have to refer to what the grounds were, and even on that basis, Gorton is screwed if she were doing it honestly. And I mean, it's unlikely that she'll do it honestly because she really doesn't believe in doing it, the way she's supposed to do it according to the law. So, because our ground is that the evidence that we have against Gorton, and we will refer to the evidence, is so conclusive that there is no option but for the court to give us the subpoena and then to make findings about the fact that we were denied the right to a fair trial, open and fair trial. Now, in doing that, she would be making some, negative findings about Gorton. But this is totally something that he has brought upon himself, by doing what he has done. I mean, I understand that it's a problematic situation. She's a judge at the arguably the same level. I mean, definitely not at the appellate level to Gorton in this situation, but the law is what it is. I mean, they're not going to fucking bankrupt us because she doesn't want to criticize him. Like, that's not, and I mean, LSB are the real fuckers in all of this because they really don't give a shit about the administration of justice or, not creating a scandal or whatever. I mean, these people will fucking eat the last infant alive if that gives them immunity from one extra thing. So the way they're arguing this and whatever they're doing with the publications and all that stupid shit, like, it's not a maintainable thing. Okay, it's Wilson versus R. It's actually a New Zealand Supreme Court authority. Wilson versus R concerned a private meeting between the chief district court judge and two police officers, at which the police officers provided the chief judge with a letter requesting that an undercover police officer appear in the district court to be remanded and sentenced by a different judge under an assumed name. Okay, so not even the same judge, by the way. The police officers believed that they had obtained the consent of the Chief Judge to that course of conduct. It was not shown that the judge who conducted the hearing at which the undercover officer appeared had any knowledge of the letter or the subterfuge. There was no suggestion that the events during the hearing itself were other than fair or public, or that the judge was other than independent or impartial. Nevertheless, Chief Justice Elias, said the right to a fair and public hearing by an independent and impartial court was compromised by the private meeting. So it's actually worse than what I had understood from just glancing it. So basically, the police officers agreed with the chief judge that the undercover colleague would be brought in a certain way, and then so they're agreeing on the procedure effectively, and then the matter will go to a different judge, not the chief judge, with whom these things are being discussed. And it was never shown that that judge ever knew about the arrangement or was affected by the arrangement, or that there was any actual procedural fairness denial during the hearing. It was not even alleged. But because that the court had been involved in a underhanded or secretive arrangement.
Yes.
And this was not a judicial capacity arrangement. This was just an administrative arrangement. So they're not predetermining what evidence will be permitted or how. So it's not a judicial function, it's an administrative function that the chief judge is performing. And even then, which makes perfect sense, because if you start doing this, then, and I mean, I was thinking about it too, like the way Ellis behaved, like on the first day. I made submissions about the non-service of the petition and all of that stuff, and she never gave any reasons and just said, doesn't matter, adjourned, and then subpoena, like on the face of it, she was inviting the thing, but she was never gonna issue it because of what they said. And then she was taking their permission to right until the last minute. She was like, do the applicants consent to the matter being referred to a judge? Like, her chambers sent the email twice to the Legal Services Board, and they weren't responding. They only responded after I threatened them. So basically, there's no way she would have done any of that if they were a private litigant. It's because they're a government body and they're, the Attorney General's department.
Yes.
So the court is basically treating them in a special way. That's the clear.
As I said before, I think this really stinks.
And I mean, the courts are like, the main function is to protect against the executive. So.
Yeah, not aid and abet them, correct.
Yeah.
I mean, would it be worthwhile just posting that the registrar's letter?
We will.
Yeah, with a comment, or your.
Yeah, no, I think we should send it to everybody, because this is
an example of
what the LSP can do. Yeah. And I think the worst aspect of it is that they have basically listed the application but won't list the evidence, or won't seal the evidence. So if something is frivolous or, vexatious, it's the application or the process you're invoking.
We understand that. And it's not their role to make that decision about the affidavit. Or
yeah.
In the affidavit. Clearly, he's out of his depth.
But it's not just that. I think what they're doing is basically setting us up to fail because they're listing the application without letting us rely on the evidence, and then on the day they'll say that, you're making these allegations without any evidence. Do you know what I'm saying? Like,
Yeah, I understand what you're saying, but
because they haven't. It's not that they have said that. So basically, what he has determined that none of the documents exhibited to the affidavit are relevant. Whereas,
which you might consider.
yeah. I mean, but if he had even if he was carrying out a judicial role improperly, he should have at least pointed out which documents he thinks are wrong, because some of the documents we clearly need. Like, for instance, how do we prove that there was no ex parte communication and she's lying, or that the emails that we had sent had actually sought extension of time, contrary to what she's saying, or any of the other things that she's basically lying about, including the fact that the emails that we sent had, she's giving the impression that we sent multiple emails with multiple attachments, and it was just one email that had attachments, and it was specifically about the change of lawyer. And she's also basically done contradictory things with the, first she says, send me the material that's unfiled, and then she says, how dare you send me the material that's unfiled, and all the stuff in between. And it's basically non-equal treatment of people that is the problem. So none of that can be demonstrated objectively, and it's just going to be assertions if she doesn't permit us to file the documents. And it was for the other side to raise an objection too. It's not for her to do it, and like.
Yeah, absolutely.
One thing that I really don't understand about the whole argument that this is not a royal commission is that, so the point is that if the executive agency does one thing wrong to harm you, then that's fine, you can raise it in the court. But if they do 10 things wrong, then you're raising a royal commission. Do you know what I'm saying?
Yeah, so you're entitled to seek, you're entitled to have the matter investigated, especially if there's a continuous example of the continuous showing of bad behaviour, or improper behaviour, illegal behaviour.
Criminal behavior, I would say. But the point is that in a royal commission, the commissioner investigates and gathers evidence and subpoenas people and calls witnesses.
I think the inference of what she's saying is, and that's sort of what people would say, it's not a royal commission. That a royal, it's very. I think what she's saying, this is not sort of a matter that is going to be considered or going to be part of, subject to a royal commission, and that's sort of a line of saying, a way of saying, well, the matter is not that big a deal.
No, that's not what the.
It's a way in which people.
Peter, okay, so she said it. She said it in the context of me raising a complaint about the barrister. So I said that she had breached the barrister conduct rule in seeking to.
I know what you're saying. I'm just trying to explain a way in which people would normally use that term, and that is to say, look, it's not subject. It wouldn't be subject to a royal commission. They're saying it's not the sort of matter. I'm not saying she's right. I'm just saying what she's referring to in there is not to say, it's not a royal commission. It's a way of saying, look, it's not a matter that would be subject to having such a big inquiry. That's all she's saying, rightly or
Yeah, my interpretation was that she was saying that you don't get to have every wrong action, you know, sanctioned by the court, because that's solely what happens in the Royal Commission, and that in this case we will just focus on the immediate thing before the court and not on the tertiary things.
No, that's not unreasonable. I'm just suggesting that she's saying, you know, it's not a matter that would be subject to a Royal Commission, so it's not a big enough issue.
Yeah.
It's not saying that's right. I'm just saying that's what she's referring to. I wouldn't read it any more than that.
Okay. All right. So I'm gonna get back to the thing, so I can send her the email, and then yeah. So we will. I think we should send the material out tomorrow. I'm gonna finalize a person for the compare thing, and then let's do a discussion as well. Okay. Cheers. Bye.
Yeah. My only point being is that I mean, maybe if the first thing we send is this correspondence, because I mean, there's all the other stuff that, you know, except that that's all damning, but this is sort of a good example of the extent at which they're going to you know, to not have to impede our hearings, and it's an obvious matter. You know what I mean? Do you follow what I'm saying?
Yeah, absolutely. I think people will need the context though. Like without the context.
Well, yeah. I think if you say, you know, it's a brief explanation. Here we are. We're trying to, you know, bring this application. We bring here's a copy. You see what application we're trying to bring.
Yeah.
And this is the excuses that we get. I mean, which is so against the law. It's ridiculous, and people will see it for what it is.
Yeah. No, I think that's right, and I think we should also do it. So the one thing is that we have to clarify that this is particularly in relation to them trying to prevent us from disclosing the thing about you know, their people being crooked, because it's not so much about the bankruptcy issue. I think the main problem is that the other proceeding they want to control